Good morning and afternoon, everyone. Thank you so much for joining us for today's webinar, Pants Optional, New Issues in Remote and Hybrid Work Arrangements. While I introduce myself and our speakers, please see the information slide that's on your screen. I'd like you to draw your attention to the survey piece in particular. We really value your feedback on our sessions, and we encourage you to fill in the survey before you log out of the webinar today. We also have an automatic CPD certification process for the webinar today. At the end of the presentation, you'll see a QR code on your screen from which you'll be able to receive your Ontario or Quebec certificates. So my name is Elizabeth Reid. I'm a partner in Fasken's Vancouver office, and I'm a member of the Labor, Employment, and Human Rights Practice Group. Within my practice, I help clients navigate the everyday and sometimes not so everyday issues that arise in the workplace. I represent clients at mediation, in the courts and administrative tribunals, including all levels of court in British Columbia, and our provincial and federal human rights and employment standards tribunals. It's my very great pleasure to have with me today some of my colleagues. So I'll introduce them. Jordan Thompson is a senior associate in both our Surrey and Vancouver offices. Jordan leverages his previous management experience to effectively understand the needs and issues that are facing his clients, and he focuses on providing cost-effective, practical, and timely advice. He provides clients with pragmatic advice in forming and ending employment relationships, collective bargaining, and navigating complex issues such as workplace accommodation. My other colleague with me today is Leslie Whittaker. Leslie's an associate in our Vancouver office, and she advises employers on all aspects of the employment relationship, from hiring to termination, and the many legal intricacies in between. Leslie regularly provides advice on employment standards, wrongful dismissal and constructive dismissal claims, post-employment competition issues, bullying and harassment, workplace accommodation, privacy matters, and human rights complaints. I'm delighted to have them both with me here today. They are fantastic lawyers and wonderful humans, and we're happy to be presenting for you. So on to our presentation. Let's have a look at what's on the docket today. So today we're going to outline the legal issues that arise with remote work. We'll share with you some of the litigation trends that we're seeing and some of the recent case law. We'll also look at legislative responses to remote work, and throughout the presentation, we've tried to build in some tips and tricks while you're dealing with your remote workforces. At the end of our prepared remarks, we have left some time for questions, so please submit those through the webinar portal, and we'll be able to address some of the questions that came in advance of the presentation as well. Now, remote work is clearly here to stay. It's no secret that office workers want it. It's popular with everybody. And it is particularly popular with both women and the people who don't have to contend with small children at home when they're working. A recent survey was done by a Canadian HR reporter just earlier this year. They surveyed over 1,000 businesses, and this is what they found. Nearly 66% of businesses are using remote work. And that remote work comes in a variety of flavors. The most popular is the hybrid of remote and in-office work at 48%. In just under 10% of the businesses, the remote work is entirely at the whim of the employee, and about 8.8% of businesses are 100% remote. So looking at the image on the right, they broke down the hybrid group a bit more to see how it was functioning. And within that hybrid group, 61% of the businesses mandate a specific number of days per week, ranging from 1 to 4. The other 39% have developed their own unique systems. Some firms use a 1 week on, 1 week off system, while others set the expectations based on workflow or on a particular number of days in a month. Of the firms that set the mandate based on weekly office attendance, or weekly in-office attendance, the vast majority require 2 to 3 days a week. Only 7% require 1 day per week, and a mere 4.82% want 4 days a week. So most popular solution seems to be 2 to 3 days a week. That adds up to a lot of work being done remotely. And with all that remote work going on, interesting legal issues were bound to crop up, and crop up they did. So I'll turn it over to Jordan to highlight some of those legal issues, and then you'll hear from Leslie on the trends that we're seeing in the courts. Over to you, Jordan.
Thank you, Elizabeth. So the pandemic didn't necessarily create new legal issues per se with remote work, but it certainly altered and increased the frequency and profile of many of these issues. The legal issues can largely be grouped into the 6 categories that we've listed on the slide there. So as you all likely know, certain aspects of employment law vary from province to province in Canada. An employee's location is largely determinative of which provincial law will apply. So with the increase of employees working remotely, often outside of the jurisdiction where their employer is located, jurisdictional concerns are very common and very important to navigate properly. Major risk for employers in this area relate to statutory compliance and employment agreement enforceability. Of course, this is not simply limited to Canada either, as remote work often crosses international borders as well, which potentially raises a host of other considerations. Return to in-office work remains an important legal issue. So here we're talking about situations where employers require an employee who has been working remotely to return to the office on a full-time or on a hybrid basis. So employers need to be careful in this, in the approach they follow to avoid issues such as constructive dismissal, and also ensure that they're navigating, complex issues such as accommodation carefully with return to work issues. In addition to ensuring that the employer is following the correct employment standards rules, remote work also creates unique issues relating to compliance with those various standards. I know in my practice personally, I've consulted with many clients that have issues relating to managing hours of work and overtime issues with remote workers. And we'll be covering that in a little bit more detail later on. Occupational health and safety and workers' compensation issues are also relevant when it comes to remote work. And really they're twofold. First, many employers who are not familiar with their occupational health and safety obligations for remote workers, such as ensuring emergency procedures and check-in procedures are in place. You can get into non-compliance issues there. The other element of that is workers' compensation issues, which arise where an employee is injured while they're performing their job at home. And, there's been a couple cases dealing with the issue of whether such injuries should be compensable under the appropriate workers' compensation regimes, which I'll be covering for you shortly. The next category there is tax and payroll obligations. So these continue to develop in response to remote work. Most of us at this point are probably familiar with the T2200 forms and changes that came from the pandemic. So we'll take a quick look at updates on the tax side, as well as some new CRA directive on payroll issues. And then finally, the last category is issues relating to privacy and security, including issues such as employee monitoring, which continue to be relevant and continue to develop. And so that's a quick overview of the legal issues, and I will pass it over to Leslie to talk about some litigation trends.
When it comes to litigation trends, there are a few areas that have been dealing with remote work more than others. So one of those areas is the workers' compensation coverage issues that arise. As Jordan had just mentioned, when an employee works flexible hours from home and their home is considered a workplace, it becomes harder to distinguish if an injury happens at home, if that has arisen in the course of employment duties, and whether or not it's covered by workers' compensation. There have also been overtime claims by remote workers. If employers do not keep records of hours worked by their remote staff, they might find themselves facing overtime claims with no evidence to rebut those claims. There's also been disputes over who pays for remote work costs. For example, unions have grieved remote work policies that did not reimburse employees for certain work from home expenses. And finally, the human rights tribunals and commissions have been dealing with complaints about remote work as an accommodation. In some cases, employees have demanded that remote work is an accommodation. In other cases, if remote work is the only accommodation offered, then it might be considered discriminatory. And beyond these categories, employees have argued that being forced to work in the office is a punitive measure and can be considered a constructive dismissal. On the other hand, employees have also argued that having to work remotely due to an injury actually damaged their career advancement opportunities and future earning capacity. So far, these arguments have not been successful in court. And now back to Jordan to discuss some recent case law.
All right. So as I mentioned, we're going to start by looking at some of the workers' compensation issues that have come up with remote work. So the first case is, I'll refer to it as the Allard case here, and it's a decision of the Quebec Administrative Labor Tribunal. So in this case, the worker was working remotely. Her office was set up in the basement of her home. And during the employee's lunch break, she fell down the stairs leading down to her backyard, resulting in a sprained and fractured ankle. So the fall occurred because the employee had dropped her personal cell phone, and she was bending down to try to pick it up and slipped and fell down the stairs. So the lower level decisions had denied the employee's claim, finding that it did not occur in the course of work. The worker appealed the decision to the tribunal, and the tribunal needed to grapple with the question of, in the remote work setting, when does such an injury become in the course of work? And so turning to the next slide here, we see the factors that the tribunal in Quebec determined to be fundamental in assessing whether an injury occurred in the course of work. It is worth noting that each provincial workers' compensation regime will have its own test and approach to this issue. So once again, the employee's location provincially is going to be important when it's making this assessment. And we'll see that difference with the second case that we're looking at. So now looking at these factors here, I won't read them out. But in my opinion, this case is actually pretty clear cut that the injury did not occur in the course of work, even though it did occur at the employee's home, which is an extension of the workplace for a remote worker. Some of the important aspects of the decision relating to these factors found that when the injury occurred, the worker was outside and was not in her home office. The worker was on an unpaid break at the time of the accident and was not required to be available during the break. The worker was not performing any work during or shortly before the accident. The literal action the employee was taking was reaching for her personal cell phone, which served no work-related purpose. It wasn't a work phone, it was a personal phone. And finally, the worker was disconnected from the employer's network at the time of the accident. So based on those assessments, the assessment of those factors, as I said, I don't think it's a big surprise in this case that the tribunal agreed with the lower level decisions and found that the worker's injury did not occur in the course of employment. The tribunal did give this interesting commentary about, the factors being assessed in order to distinguish between whether a remote worker is considered to be in their personal sphere or a professional sphere. All factors considered in this case, the employee was clearly determined to be in her personal sphere at the time of the accident. The case does interestingly refer to a prior decision of this same tribunal that determined a worker did suffer a compensable injury when she left her workstation in her home and fell down the stairs immediately after leaving her workstation on her way to take a dinner break. So even though the employee was technically on a break at the time of the injury, the tribunal focused on the fact that she had just left her workstation prior to the accident. And then so you see the three key points there, basically where the tribunal ended up is location, timing, and whether the worker needed to be available to perform employment at the time of the accident were the deciding factors. In this case, determining that the injury was not a compensable claim. And then in contrast to this decision, now we're switching over to look at one from the Alberta Appeals Commission for Alberta workers' compensation. So in this case, the worker was working remotely at home when she smelled smoke from her home office. The worker went to investigate the source of smoke and saw a small fire on her neighbor's balcony. So the worker yelled out for her neighbor, but did not receive a response. So at which point she ran back into her apartment. At this point, she heard the neighbor call back to her, so she ran back out to the patio. And on her way out to the patio, she tripped over the bottom portion of the door frame that was elevated. She fell out to the patio and fractured her arm. So like the Allard decision in Quebec that we just looked at, the lower level decisions rejected the employee's claim, finding that the injury did not occur in the course of employment. And then so the worker appealed the decision, and which led to this decision we're looking at. The commission referred to two concepts that we don't see anything about in the Quebec decision, those being the concept of an employment hazard, and then also being the concept of positional risk. So first, the commission noted that an injury arises out of employment when it is caused by an employment hazard. An employment hazard is an employment circumstance which presents a risk of injury, which may be directly related to the worker's occupation, or it can be incidental. Second, the commission noted that an employment hazard can arise from what is referred to as positional risk. And what this means is that the worker's employment itself causes the employee to be at a certain place at a certain time when they're exposed to an employment hazard. So with these two concepts in mind, the commission referred to the legal test in Alberta, which is if an injury occurs in the course of employment, when it happens at a time and place consistent with the obligations and expectations of employment. The commission then goes on to list a number of factors, which are quite similar actually to the factors that the tribunal in Quebec applied in the Allard case. And the ultimate outcome here is that the worker's appeal was granted and the claim was accepted. So the lower level decision was overturned. In coming to this decision, the commission noted the following important facts. One, the employee was required to be at her home residence from 8 to 4 each day. Both the fire itself and the raised door frame were considered employment hazards, and the worker ultimately fell and was injured because of these hazards. The worker was on paid time during the accident. And finally, the worker had a remote work agreement, which required her to respond to emergencies, and it also included an obligation to evacuate the building in the case of a fire and to keep a fire extinguisher handy. So all of these factors taken into account, we see a similar situation between the Alberta and Quebec cases, but with some obvious factual differences that brought the Alberta decision within the WorkSafe or workers' compensation protection to explain the differing outcomes there. So in terms of takeaway from these two decisions, the first takeaway is that an assessment of whether an injury suffered by a remote worker is deemed to be in the course of employment is extremely contextual and factor driven. So, it's not a one-size-fits-all legal test. It's going to be driven by the factors that led to the injury. And then secondly, the other takeaway here is that, and we see it in the Alberta decision, workers' compensation policies, will be interpreted and applied in accordance with something like a remote work agreement. So having carefully drafted remote work agreement or other types of agreements could provide more certainty and more clarity into these types of remote work injury situations. And so with that, I will pass it back over to Leslie to look at some other litigation developments.
There we go. Moving on to disputes about overtime in remote work arrangements. When it comes to overtime, there are some key things to remember. First, that record-keeping obligations rest on employers according to employment standards legislation. So it's the employer's responsibility to keep track of an employee's hours worked. And if an employer doesn't do that, then they can be at the mercy of the employee's personal records, and it can be an uphill battle to contest employee assertions about those hours. Most legislation also doesn't have specific criteria for authorizing overtime hours. So without clear policies, employers are generally liable to pay for overtime that was worked, whether or not it was officially authorized. And it's important to remember that policies and practices are equally important. If you have a policy that prohibits employees from working overtime, unless it's approved, but that policy is never enforced, then you will not be able to rely on it to guard against overtime claims. Recently, there was a remote work overtime claim that was resolved in favor of the employer. This was an appeal within the BC Employment Standards Tribunal last year, and the employee made an overtime claim for around $15,000 plus $3,000 in penalties against the employer. And in the original decision, the delegate accepted the oral evidence of the claimant that he had worked 418 overtime hours in only 5 months of employment. He said that he'd worked from home approximately 4 hours every weekday evening. The claimant did not have any documentation supporting these work hours, but the delegate relied on the claimant's testimony and the testimony of his roommates and friends who said that they'd sometimes observed him working from home at 8 o'clock. The employer denied that the employee worked overtime and argued that there simply wasn't that much work to do. The employer also had no records, though, but provided oral testimony that the claimant only worked 6 to 8 hours per day and often left early to go to the gym. The delegate found that the overtime claims were outlandish and improbable, yet the delegate accepted the claimant's evidence and found in favor of the claimant on the basis that the employer had failed to meet its statutory obligation to keep records of work. However, on appeal, the determination was canceled and it was sent back for redetermination. The appeal member found that the delegate had leapt from evidence of evening work on 4 occasions to simply accepting the claimant's assertion that he'd worked these 400 hours of overtime, despite various credibility issues on the record. The member held that where an employer has failed to keep any payroll records, the delegate may accept records or oral evidence of an employee unless there are good and sufficient reasons to find that those records are not reliable. So the takeaways here are that appellate tribunals may be skeptical of excessive hours claims, more so than the first level of a tribunal, so it might be worth to appeal depending on the facts. Hours of work should be tracked and reported as required by employment standards legislation. And employers should check in regularly with remote employees to assess workloads and see whether or not they are working overtime hours. Employers should also ensure that employees are well aware of the procedures for recording their hours, including logging in and out every day, filling in timesheets, and especially with remote workers, having those employees acknowledge and agree in writing that no hours will be considered worked if they haven't been communicated and approved by the employer in advance. It's also important to avoid willful blindness of overtime work. As noted earlier, it's not an excuse for an employer to say it just didn't know that the employee was working overtime. If an employee worked overtime hours and they can prove it, they will be entitled to overtime pay. Turning now to cases about out-of-pocket expenses incurred by employees in relation to remote work. This has primarily come up in the labor context with unionized employees. In this particular case, the Toronto District School Board, at the start of the pandemic, the school board implemented a policy that out-of-pocket purchases made by staff related to the transition to working from home would generally not be reimbursed and would only be permitted if they were considered an essential item for work and pre-approved by the employer. Some employees purchased on their own initiative items that they believed were necessary in order to carry out their work, including office supplies, furniture, and laptops. The union argued that the school board ought to reimburse these expenses despite the policy. The arbitrator considered the following issues. Did the employer violate the collective agreement or the Employment Standards Act? Was the school board unjustly enriched by passing on the costs of remote learning to its employees? And did the school board reasonably exercise its management rights? The arbitrator found in favor of the school board. First, there was no provision in the collective agreement that spoke to expenses, so we concluded there was no agreement between the parties as to how these types of expenses would be dealt with. The arbitrator also found that the policy was not a breach of the Employment Standards Act because while the employees may have incurred expenses, the employer did not direct them to do so or withhold wages from the employees to cover those expenses. The arbitrator also found that there was no unjust enrichment, and the overall conclusion was that the policy was a reasonable exercise of management rights. A key takeaway here is that the policy gave employees an opportunity to seek approval for the expenses, but it was clear that the school board held the ultimate authority to determine whether or not something was an essential item, not the employee. It was also important that the school board did not provide any reassurances that the employee purchases would be reimbursed. A note of caution, however, in this case, in determining that the no reimbursement approach was reasonable, the arbitrator relied heavily on the unprecedented circumstances of the pandemic, often referring to the highly unusual circumstances and unusual and difficult circumstances. So outside of these unusual circumstances, it might be reasonable or it might be unreasonable for employers to refuse to reimburse certain costs incurred by employees, especially if there's no clear policy. Other arbitrators have followed the same reasoning. In a similar decision in 2023, the University of Ottawa implemented a policy that it would not reimburse any out-of-pocket expenses for work-from-home equipment. If employees needed equipment, the policy was that they were to ask the university, and the university would provide access to such equipment if the university determined it was necessary to perform their work. Again, the arbitrator found that this was a reasonable policy. As a reminder, generally in both the union and non-union contexts, employment standards legislation in Canada does not allow employers to make employees pay for business expenses, even if the employee agrees to it. Employers can require remote workers to use their own equipment and furniture, but they are liable for any business use operating costs of that equipment, and employers may be liable for maintenance and replacement costs from business use. While it may seem attractive at first to have remote employees use their own technology and equipment, it is easier to exercise control over company-owned equipment, and this helps avoid disputes over expenses. Over to Elizabeth now to cover relevant human rights cases.
Thanks, Leslie. So I think I probably got the fun section here. So in this section, we're going to have a look at two cases involving remote work as an accommodation under human rights law. I've got one case for you from the Federal Court of Appeal where the employee wanted remote work as an accommodation. And just to switch things up and keep it interesting, I've also included a case from British Columbia where the worker most decidedly did not want remote work as an accommodation. So our first case is Tarek Kaminker versus Canada, the Attorney General. And that's a Federal Court of Appeal case. This case started off as a grievance alleging breach of non-discrimination language in a collective agreement. Like many other collective agreements, this one contained a clause which prohibited discrimination on various protected grounds, including the classic family status, religion, and disability. It also had a very detailed clause about religious observance, one that I haven't seen as frequently, and which required the employer specifically to make reasonable efforts to accommodate employees who needed time off to fulfill religious obligations. That sort of mirrors what the requirement is under human rights law anyway, but it was interesting to see that in this particular agreement, that they had expressly written that in. The employer was the Public Prosecution Service of Canada, and the griever, Ms. Tarek Kaminker, worked as a Crown prosecutor. I still wonder how you managed to have lawyers under a collective agreement, given some of our crazy work hours and conditions, but there you have it. They seem to be able to work it out here. Now, the griever's job involved regular court appearances. She had to go to court, as much as 3 to 5 times a week, and she worked in one of the busiest criminal courts in the country. In addition to her extremely busy job as a lawyer, Ms. Tarek Kaminker also had an exceptionally busy home life. So she and her surgeon husband had 5 children. They were all under 18 years old. My own mother had 3 under 18, and I think that was enough. I can't imagine having 5. And some of their children also had special needs, including significant health-related needs and also some learning disabilities. Her family is Jewish, and it was very important to her that the children were raised in the Jewish faith. So they had a number of activities as well related to their religious observance, the children's religious education, etc. And in particular, they observed the Sabbath each Friday. And as the senior woman in the home, it was her role to light the candles at sundown. And she took that role extremely seriously, and there was no question in the case that this was a very important and meaningful part of her religious observance. So for many years, the griever had a remote work agreement that let her work from home on Thursdays and Fridays. However, eventually, and we're talking like years, probably about 10 years, I think, she had that remote work agreement. Her managers got kind of brave and decided, well, this actually isn't working for us. And they decided that they would not renew the telework agreement. And the rationale for that was that it really restricted what work could be provided to the griever. As a regular part of the job, she was expected to be in court. And with this telework agreement, she hadn't been able to conduct any of the lengthy jury trials, which would be a normal expectation for the lawyers at her level. So essentially, her colleagues were having to take on that work, and she was not having to take it on because she could stay home Thursdays and Fridays. Now, as you can imagine, with a very busy household and a long-standing kind of set of arrangements for that household, the griever was extremely unhappy about this development, very unhappy that the telework agreement had been changed, and she brought a grievance against the employer. And unsurprisingly, she requested as her remedy that the employer reinstate that remote work agreement that she had been enjoying previously. And the griever argued that taking away the remote work agreement amounted to discrimination on 3 different protected grounds. So she relied on religious affiliation, family status, and also disability. And under the disability heading, she said that the inability to work from home had caused a disability to herself. At arbitration, the griever failed on all 3 of those fronts, and no breach of the collective agreement was found. Now, a major concern in this case was the griever's credibility. So the adjudicators found, and the kind of direct quote was that she was often given to hyperbole, as well as being less than frank and omitting important facts. Not great things for a lawyer, and particularly, she's going to be held to a bit higher standard as a lawyer, I think in that respect, which also probably played into this case. By way of an example, the griever produced 2 letters from Dr. Wise. Now, Dr. Wise was the children's pediatrician, and the letters were given to the employer during the accommodation process, and they were looked at in the course of the hearing. Now, the letters were kind of unusual. They were extremely lengthy. They contained detailed narratives about the family's dynamics, its schedule, its needs, but not a whole lot of medical information. So what Ms. Tarek Kaminker did not initially tell the board in her testimony was that Dr. Wise had not actually written these letters. He had signed them, but the letters had actually been written by Ms. Tarek Kaminker and her husband. Now, this only came out in the course of her cross-examination. So the employer's counsel kind of dove into that and discovered that, these were not written by the doctor. He just sort of popped his John Henry on it, and they went from there. Now, needless to say, the weight of that quote-unquote medical evidence was significantly reduced by the fact that it hadn't actually been produced by the doctor. So that was one of the, just an example of these credibility issues. In terms of the griever's substantive claims, the board found, I think primarily on the credibility side, she didn't actually even have a disability. So no accommodation was required on that front. The kind of general overwhelm that she was experiencing did not amount to a disability. One of the other things that they said about her credibility was she had an intense tendency to overstate things. And I think they found that her claim to personally have a disability was one of those overstated claims. With respect to her family status, she was unsuccessful on that front as well. She hadn't demonstrated that she had made reasonable efforts to meet her childcare obligations in ways that would allow her to attend work in person. And similarly, she hadn't proved that, if she had made those efforts, she wouldn't be able to meet the children's needs. So essentially, the court, or the board at that stage was just not satisfied, that this was really necessary. On the matter of the religious discrimination, the board found that the griever was really just insisting on the accommodation that was perfect for her, which was that remote work on Thursdays and Fridays. But she was only entitled to reasonable accommodation. And the facts on that point are kind of interesting. During her testimony, Ms. Kaminker had explained at some length how convenient the teleworking had been for her. So in particular, she said, it alleviated her lengthy Friday afternoon commute, and it let her get home before sundown in time for the candle lighting ceremony. And she described in support of this kind of allegation, a specific incident from shortly before she testified. So she had been in court, the hearing had run late, she got stuck in traffic on her commute on the way home, and as a result, she wasn't able to discharge that religious obligation related to the candle lighting ceremony. Now, she put forward this example specifically to demonstrate that it's her employer, it's their fault, they are the ones preventing her from discharging her religious obligations. Now, interestingly enough, what she didn't disclose, either in her evidence in chief or even under cross-examination, was that she was the one who had scheduled the hearing for the Friday afternoon in question, and also that the employer had had absolutely nothing to do with the timing of that court appearance. And this information only came out at the end of her testimony in response to questions from the board. So, and at that time, in talking with the board, she acknowledged, well, no, she actually hadn't raised any concerns with the court about the scheduling. She hadn't talked to her opposing counsel about the timing of the hearing and whether it could be scheduled for a different time. And she hadn't mentioned to anybody, well, I can't do this because on Friday afternoon, can we move it to Monday because I need to get home in time for, this important religious observance. Now, the other interesting piece was that, while the employer hadn't agreed to have her do the full-time remote work on Thursdays and Fridays, they had said, we will give you the flexibility to leave early on Fridays so that you can get home for the Sabbath. And so that was something that they had absolutely offered. There was no question that that was available to her. The other piece of that was that, she controlled her own court scheduling. So the employer actually wouldn't have even been aware, or certainly her superiors wouldn't have even been aware of this scheduling issue. So based on that evidence, the board held, I kind of love the quote, it was Ms. Kaminker's own lack of planning, not the lack of a telework arrangement, that had created that adverse impact on her religious practices. So they weren't overly sympathetic to these issues because they essentially saw her as creating some of them herself. Now, Ms. Kaminker's grievance was dismissed, and that dismissal was upheld on appeal. So our key takeaway from this case, employees often desire a remote work schedule as sort of that perfect accommodation. But as long as the employer is offering accommodation for what is, sort of really and justifiably needed, not just wanted, then the employer can be justified in denying remote work. One of the challenges, of course, you still have to go through this whole process if the employee doesn't agree. But ultimately, the employer here was successful because they had offered accommodation for, the part of, Ms. Kaminker's kind of life and status that needed accommodation for that Friday ceremony. But they didn't have to go so far as giving her the full day off on Thursdays and Fridays to work from home. So where remote work is sort of merely desired or preferred, it doesn't necessarily have to be provided as an accommodation. So now that we've looked at one case where the worker really, really wanted that remote work, let's contrast that with a case in which the worker really did not want remote work. So this next case is Fenwick and P&I Media Inc., quite a recent case from our British Columbia Human Rights Tribunal. And this case involved an application by an employer to dismiss a human rights complaint on a preliminary basis. So here in British Columbia, we have this opportunity as employers, a little bit more restricted more recently, but generally speaking, there can be opportunities to ask for kind of preliminary dismissal well before a hearing, if you're of the view that the case has no reasonable prospect of success. And I love the facts of this case. I think they're really interesting, particularly as they say all kinds of interesting things about our society and what our pets mean to us, and what are kind of things that are happening in the offices, to attract employees, etc. So the employer P&I Media, it was a really hip software company, and it had a dog-friendly office. It was like all puppies all the time. And the complainant knew of that policy when she was hired, but the complainant has a severe dog allergy. So exposures to dogs causes her, physical symptoms. She gets asthma, she gets migraines, she gets painful inflammation. There was no question that she overstates this or anything. This anywhere there was a dog was going to create a problem for her. And that allergy was disclosed. The fact that she had a dog allergy was disclosed during her interview. And she was hired. Now, the employer first tried to accommodate her within the office. So among other things, it tried to make sure that no dogs went near her, and that the dogs were excluded from the meeting rooms. But ultimately, nothing was working. People would forget that she was not supposed to be near the dogs. People would forget that the dogs weren't supposed to be in the meeting rooms. So it sort of wasn't working on that practical level. And then they even considered having an entire floor on which the dogs would not be allowed. But then they decided that wasn't going to work because of the HVAC system. So after they tried a bunch of different things, finally the employer said, look, I'm really sorry, we just can't have you and the dogs in the office at the same time. So you're going to be permanently accommodated by working from home. And Ms. Fenwick was not very happy about that. She said that was not a reasonable accommodation for her allergies, and she objected to it. And she filed a human rights complaint while she was still employed at the company. Now, P&I applied to dismiss that complaint on this preliminary basis, and it was really confident that it would be able to prove that the ability to be around dogs in this particular office is a bona fide occupational requirement, and that Ms. Fenwick had been reasonably accommodated. And it pointed to some of the reasons why they had the dogs in the office, the importance of being, a competitive employer with this really wonderful perk in a really tight job market, and a few other reasons why it was wonderful to have the dogs in the office. Now, for her part, Ms. Fenwick said, well, this is crazy. A requirement that I work with dogs nearby me is not rationally connected to my work as a software developer. So I don't think you can meet that test that having dogs in the office is or being able to work with dogs in the office is a bona fide occupational requirement. And one of the kind of takeaways from this decision is really that, working from home is not necessarily a panacea. So there can be really good reasons why working from home is not a suitable accommodation. And in particular, Ms. Fenwick argued that working from home wasn't reasonable here for the following reasons. So first of all, when she started working remotely, she was the only person doing it. So it made it very difficult for her to connect and collaborate with her colleagues. They really weren't set up for remote work. And then by default, she was getting excluded from the natural kind of flow and exchange of ideas in the office. And originally, even the company had agreed that because of the nature of her role, she was a software development lead, it wouldn't be appropriate or workable for her to work entirely at home. She had a leadership role, and she was expected to have fluid interaction and collaboration with her colleagues and her direct reports. So essentially, Ms. Fennick was making all the kind of arguments that we usually see the employers making to try to convince people why they need to be in the office. So she was taking that position. And when the tribunal kind of looked at the decision and whether it was going to allow it to proceed, it found that the reasonableness of this permanent work from home proposal really depended on whether the company could prove that underlying premise. Essentially that it would be undue hardship for the company to remove dogs from all or most of Ms. Fennick's workplace. And if the employer could remove the dogs without undue hardship, then it was going to be open for a tribunal at a hearing to decide that keeping the dogs at the office and making Ms. Fennick work from home was not a reasonable form of accommodation. So the Human Rights Tribunal had a look at this, and they don't make any findings on the merits at this particular stage, but they did decide, this is a worthy argument that Ms. Fennick has brought forward, and they decided to let the matter go to a full hearing. I'm quite excited. I hope we can tune in next year when we'll have a full decision on the merits of that case. I sort of hope they don't settle that one, because I think that would be very interesting to see. So there you go. Dogs in the office or people in the office. That wraps up our section on the recent case law. So I'll turn it back to Jordan and Leslie to give you an update on some of the legislative changes that we're seeing in response to this era of remote work. Over to you, Jordan.
Thanks, Elizabeth. Okay, so we're going to shift gears and talk about some legislative and policy responses to remote work. We'll take a quick look at tax policy from the CRA. We'll look at some legislation that's been introduced in Ontario, which deals with employee monitoring and the right to disconnect. And then finally, we'll take a look at some international responses to remote work. And so starting with tax policy from the CRA. So if anyone is craving a nap or anything, that was your cue. On January 1st of 2024, the CRA introduced a new administrative policy relating to the payment of wages and the determination of a worker's province of employment, or a POE. So determining a POE is relevant to ensure that proper deductions are withheld and that the tax-related obligations of an employer are complied with. So not much has changed actually under this new policy for people who work exclusively remotely. They're not captured by the new policy, and they're going to continue to be deemed to have a province of employment where either one, the employer's payroll department or records are located, or two, the physical location that incurs the expenses related to the employee's employment. So not much has changed there. What the new policy does address is situations where employees come into the office on a part-time basis, or they're under a hybrid model. And so the POE process is now designed to give employers guidance in terms of which POE is applicable based on the employee's terms of employment and location. So for example, where it's going to come into play is if you have an employee in BC and kind of payroll is set up in Ontario, and if the person in BC was fully remote, the province of employment for tax-related deduction purposes would be Ontario. But if that person in BC is required to come into the office location in BC from time to time, then BC will likely be the province of employment for tax-related purposes. And the CRA actually has a very helpful webpage set up for this. So it's set up as a number of questions that you can click through to determine which is likely the province of employment for any given employee. So if you're navigating any concerns about that, it's actually a pretty helpful resource to figure that out. And then Just quickly on the T2200 forms, assuming we're all kind of familiar with how those are used and what their purpose is at this point. They've been updated and presumably, or statedly been made easier to complete and process for employers. And so these should be issued where any employee they should be issued to any employee who the employer requires to work from home. The employee is required to pay for expenses relating to their home workplace, and the employee works at least 50% of the time from home for at least 4 consecutive weeks in a taxed year. And so if those factors are met, the employers are obligated to provide a T2200 form for those employees for their personal tax purposes. And we've seen, and this is not a new development necessarily, but it is one of the few legislative responses to remote work. And so Ontario, the province of Ontario amended their Employment Standards Act in 2022 to add a requirement that certain employers have a written policy addressing electronic monitoring of employees. As far as I'm aware, to date, Ontario's approach is unique here, and no other provinces have enacted similar legislation. And so the legislation basically confirms that any employer in Ontario with more than 25 employees must have a written policy addressing employee monitoring. In terms of content, the policy must provide whether or not the employer electronically monitors employees while they're working remotely, and if so, a description of how and when that monitoring occurs. The other important content it must include is that the policy must confirm for which purposes the information is gathered might be used. And perhaps it's most important to talk about what the amendments do not do. So the new ESA requirements on Ontario do not establish rights for employees not to be electronically monitored. And they also do not create any new privacy rights for employees that they did not already have. It's really more of a transparency measure so that certain employers must inform their employees that they have certain electronic monitoring systems in place. So whether or not employee monitoring is justified, which is always kind of an interesting question with remote workers, it's still going to require that traditional balancing of individual privacy interests with the rights of the employer to effectively run and manage its business. And so with that, I will pass it back over to Leslie to talk about the right to disconnect legislation.
That's right. So other laws emerging from the ongoing prevalence of remote work is the right to disconnect. The right to disconnect is the right of workers to disconnect from workplace communications outside of workplace hours. A little bit of worldwide background. It was first legislated in France in 2017, so before the pandemic, in response to the changing work practices and new technologies such as smartphones that made it possible for workers to be online at all times. In France, the way it's set up is that it only applies to employers with at least 50 employees. It requires employers to annually negotiate disconnecting from work agreements with employee unions. And the law doesn't make it illegal for employers to email workers outside of working hours. What it does is it prohibits employers from sanctioning and punishing workers who do not respond to work communications sent outside of working hours. Various other countries around the world have followed suit with their own versions of right to disconnect laws. While it's rare, some countries have actually adopted a totally universal approach where right to disconnect legislation applies to all workplaces, not just ones of certain sizes, and to all employees in those workplaces without exception. However, you don't have to wait for legislation to give employees space for their private life. Some companies have actually taken it into their own hands to ensure that employees regularly disconnect from work. Company level initiatives have been quite popular in Germany, for example. Volkswagen's approach is to freeze access to all work emails, text messages, and video calls between 6:15 p.m. in the evening until 7 a.m., except for managers and high-level technical experts. In Canada, we haven't taken significant steps in this area. The only legislation that's currently in force regarding disconnecting from work is the Ontario Working for Workers Act. But the federal government has recently committed to amending the Canada Labour Code to include a right to disconnect for federal workers, which we will also look at. In terms of the Ontario right to disconnect policy, as of 2022, this legislation requires employers subject to the Employment Standards Act in Ontario to have a written policy on disconnecting from work if they are a workplace that has 25 or more employees in Ontario. The policy must apply to all of the employer's employees, but it's a soft statement because the policy can actually be different for different groups of employees. And similar to other right to disconnect laws around the world, the legislation is again limited only to work communication. So it defines disconnecting from work as not engaging in work-related communications, including emails, telephone calls, video calls, or sending or reviewing other messages so as to be free from the performance of work. However, this legislation does not address other tasks that employees might find themselves doing outside work hours, like research or general work requirements. Most importantly, similar to the electronic monitoring requirements in Ontario, this legislation does not actually create any rights for employees to disconnect from work communication. It simply requires that employers have a policy about disconnecting from work and doesn't actually provide requirements about what needs to be in the policy. So the policy could be that employees must work and must respond to emails within 1 hour, no matter what time it is, or face penalties. The employee may have to be paid for answering those emails. And of course, this kind of policy wouldn't be in the spirit of the right to disconnect, but it would technically be a valid disconnecting from work policy under the Ontario law. And similar to the electronic monitoring, the legislation also doesn't contain any penalties for an employer failing to comply with the policies they create. So it is without any teeth, and it's more of a symbolic exercise, but it does require employers to turn their minds to the issue. That being said, the employer, if the employer does decide to give employees an actual right to disconnect from work in their policy, then an employee can enforce that right at the Employment Standards Tribunal. Otherwise, Quebec is the only other province that's tried to implement right to disconnect legislation. It actually introduced a bill first in 2018, which did not pass, and again more recently in December 2021, which also did not pass. That bill proposed workplaces with 100 or more employees would need to develop an off-duty disconnection policy. And it did include penalties for noncompliance between $2,000 and $50,000 for first offenses, depending on the size of the company. Looking at the potential change to federal laws to include the right to disconnect. So the Canada Labour Code currently does not provide a right to disconnect, but the Canadian government has been working on it. In 2019, this first came up, and the Minister of Labour made a commitment to give federally regulated workers the right to disconnect. And from there, a right to disconnect advisory committee was established with representatives from employers and unions and other non-government organizations. Now, just recently, the 2024 federal budget proposes to provide $3.6 million over the next 5 years to establish this right to disconnect. The proposed amendments to the code would require federal employers to establish and periodically update a policy on disconnecting from work-related communications. This sounds very similar to the Ontario Act, But it is anticipated that the goal is actually to provide employees with statutory protection from not responding to awkward communications. Still, that being said, currently the proposed legislation really only refers to creating a policy on disconnecting and only requires that the policy of general rules about work-related communications outside of scheduled work hours, and that it set out the employer's expectation and any opportunity for employees to disconnect. While Canada hasn't done much legislation about remote work, other countries have from 2020 until present and are still developing those laws. So as a fun overview, I just took a look at different laws around the world where remote work arrangements are affected. So as you can see, in various countries, employers are required to enter into individual remote agreements with each employee who will work remotely. Obviously, this is good practice, but in these countries, the governments have actually mandated it. In many countries, employees who are caregivers to children, individuals with disabilities, or elder adults are either entitled to or must be given priority to remote work positions or flexible work arrangements. In Portugal, remote employees must actually meet in person with their employer once every 2 months. And in Spain, legislation says that remote work arrangements should only be on a voluntary basis and that employers should not force employees to work remotely. And as discussed already, of course, many countries have implemented right to disconnect laws. Over to Elizabeth for some tips and tricks.
Thanks, Leslie. Now, we've been including kind of throughout the presentation a few sort of tips and takeaways as we've gone through the case law and looked at some of the legislation. But before we get to our Q&A, we thought we'd leave you with just a few more. And I think the first kind of key thing when you're dealing with remote work is really making sure you know and assess your risks. So in addition to being able to spot the issues like the ones that Jordan highlighted at the beginning of the presentation, and getting local advice in the jurisdictions that you have people in, you need knowledge about who on your team is working remotely and where they are. It sounds way straightforward, but I have seen more than a few cases in my practice where an employer didn't realize that a remote worker had moved. And once they did find that out, didn't realize that in the new jurisdiction, their very carefully drafted employment agreement was totally unenforceable. This was something that could have been avoided if there'd been an expectation that the employee advised them if they were moving and get permission from the company, before kind of proceeding with their work in that new location. If somebody just wants to start working from their cottage in the Kawarthas and they're usually in Toronto, you may not care if they were already remote. If all of a sudden they want to be a cyber road warrior and work from all over the world, you might have a few more concerns about that. Now, another kind of other key thing is really make sure you have proper documentation. If you can point to a piece of paper, whether on an online PDF or something with a wet signature that says exactly what the terms of the remote work are, whether it's guaranteed, whether it's permanent, all of those kinds of things, you're going to have a much better case for doing whatever you want to do. That's going to help you both when you're having the discussions with your remote workers because those guidelines and expectations have been clearly set out. I'm being a bit selfish here because it's going to make my job a whole lot easier when I go to court and try to justify why this worker needs to come back or why it wasn't a constructive dismissal to bring them back. And essentially, help me help you support your case. If you do get into a dispute with your remote workforce. And so, in terms of the kinds of things that you want to think about when you're putting that sort of paper together, it's going to look a little bit different depending on the employee. If somebody's permanently remote, you never expect them to come into the office. You might put that remote work agreement right in their employment contract because that is a fundamental term and it's not expected to change. If you have somebody who's just going to be doing remote work either as an accommodation or on a temporary or a trial basis, you may not want to build that in as an absolute sort of contractual right. You might want something that's a lot less permanent. Kinds of things you're going to put in those agreements. You want to look at what's the location. So where are these people actually going to be working from? What happens if there's a change in the location? Do they need to get permission first? How reasonable is the company prepared to be about that? All of those kinds of things. Obviously, you probably don't want something that says, well, you can't go and work from your cottage, but you might well want something that says as soon as you cross provincial borders or you're in a different time zone, we need to know about that. You may want to consider provisions about hours. So what kinds of hours are people working? As we saw with our occupational health and safety cases, the hours of work can help determine, when is someone on sort of quote unquote company time or not. The other thing that I have sort of built into agreements for some of my clients that have remote workforces are kind of key or core business hours, particularly if people are going to be in a lot of different time zones. So sometimes we'll say, okay, this company runs on Pacific Standard, that's fine if you want to be somewhere else, but our business meetings, we expect you to be available from Pacific Standard, whether that's the middle of the night for where you are, that might be fine. If you want to stay up all night, we don't care. But you have to be available during the time that the business is open. We want to include things like expectations about coming in. So are they going to be expected to come into the office either occasionally? Can you revoke the remote work agreement entirely and have them come back to the office full time? These are all the kinds of things that you can address in that documentation. Also important is the occupational health and safety requirements. Those we often will build in, at least to some extent, in your workplace policies and procedures for remote workers, because essentially you really have not much choice but to shift the responsibility for at least setting things up in a safe way, to the worker on a practical level. Legally, the liability is still going to be with the employer, but if you can point to things that show that you had the worker's safety in mind and that you tried to put in place all the proper things to protect that worker when they're in that remote work environment, you're going to be in a much better position than if you didn't turn your mind to it at all. Some employers will do a safety checklist, and literally the employee walks around their home office and sends back the form. It says, yes, I looked for the tripping hazards. Yes, I taped down the rugs, whatever the other things you need to put in there. Whether the employee actually does it or not, well, I'm a bit skeptical. I know when I'm working from home, I'm frequently on my couch, which is probably not the most ergonomic workspace, but at least you'll have the documentation to show that the expectations from the employer side were made clear. And then if the employee doesn't meet those, there may be, hopefully be more consequences for the employee than the employer. Other things that we like to include are things about confidentiality and security. If you have people working from home, of course, you have that risk of documentation going missing, people printing things out and leaving them on the kitchen table. Those are all, valid concerns. Even just if you have a fully remote worker who's printed a bunch of stuff out at their office at home, how do you get that back when the employment relationship ends? So these are all the kinds of things that you can deal with and put in place in your contracts, your sort of policies and temporary work from home agreements. And they're always, where each piece goes is really going to depend on, how strong do you want that to be? So things that are actual contractual obligations are going to have more weight, than things that are you're just in your policies. So that's the kind of documentation side of things. If you're going to have workers who are in multiple jurisdictions, and this is sort of my last big point here, you need to really think carefully about the way to hire them, and particularly if you're looking at an international workforce. While you might be delighted to open a brand new shiny office for your expansion into India, if you only need a few workers in that country, that probably isn't realistic. I've had a couple of clients that wanted to hire people in sort of international jurisdictions, And once they realized some of the concerns about the tax implications, whether they'd be considered doing business in that location just because they had some workers there, even just figuring out exactly what the rules were, was going to be extremely, extremely expensive, and didn't make sense if you were just having a couple of people. So if you are going to have a lot of workers, you might consider getting local advice and finding out whether, if you want to still have that direct relationship, that you enter into some kind of an independent contracting relationship. Definitely get local advice on that, though, because there can be risks hiring independent contractors. Your other option is to enter into a commercial arrangement with a labor contractor who's going to provide you those workers, instead of entering into that direct and really heavily regulated employment relationship. Now, you may have also have heard of professional employer organizations, also known as PEOs. So if you know you need a few remote workers who are going to be based in another country, and you aren't ready to kind of expand and have your own kind of full-on operations there, and you also don't want to take the risk of engaging them directly, a PEO can be a nice option. So these are organizations that are based in various countries, and their sole purpose is essentially to hire employees so that you don't have to. So you meet with the PEO, you tell them this is the kind of work that we need done. You may even have a candidate lined up that you want, that you know you want to use. And for a fee, usually based on a percentage of the employee's salary, the PEO will hire them, be the official employer, and make sure all the local rules are complied with. Now, and then the PEO tells the person that was hired, okay, we know you're our employee, but we're going to get you to take, for example, all your instructions from Leslie. So in that situation, if Leslie's the employer, I'm the PEO, I have a relationship, a contractual agreement with Leslie about that work. And then our worker will make Jordan the worker. He takes all his direction. He's hired by me. I'm his official employer of record, but then he takes all his direction from Leslie. Those can be quite interesting from a contractual perspective, because you'll have the contract between Jordan and myself as the PEO. You'll also have a contract between myself as a PEO and Leslie, so that it's really clear whose responsibility is what. So I'm not going to want to pay Jordan if Leslie hasn't first put the money for Jordan's salary in my bank account. So there are usually kind of arrangements there, but they're not usually overly complex. And they usually will make sure that everybody's kind of playing nice in the sandbox in terms of making sure the worker is well treated. So the thing that kind of really works well with the PEO system is it gives you the comfort of knowing that you're complying with those local employment regulations, while also avoiding the risk that you're going to be found to be doing business in that foreign jurisdiction because you're directly employing someone there. Now that brings our prepared remarks to a close. We do have some time for questions and answers, so I will turn things over to Leslie and Jordan to be our mediators for the Q&A session.
Yeah, thanks so much, Elizabeth. So we had a number of questions come in advance too, and a lot of them had a certain themes to them. The first one was one of those, which I'll shoot Leslie's direction. And generally the question is, can an employer require that a employee turn their camera on for remote meetings while they're working from home?
Yeah, well, luckily, so that's an easy one. The answer is absolutely yes. Remote employees have the same rights and obligations of, as on-site in-office employees, and they have to follow the reasonable directives of their employers. Think of video calls as being an extension of the office. It's a meeting. If you ask an employee to come to an in-person meeting, they, can't say, no, I'm just refusing to come. So employers can absolutely have employees turn on their cameras and require that.
Why don't I ask you a secondary question, which I think is generally similar. Can an employer mandate an employee's dress code when that employee is appearing on a remote meeting as well?
There we go. Same thing. So, if you have a dress code about what's required to dress and look professionally for meetings, then that is what the remote worker also has to do when they're showing up on camera. And Jordan, I guess I'll shoot a question back at you again based on what we received. So one of the questions we got was, what are some considerations when an existing employee asks to work remotely from another country? And what are the differences there between, a short-term stint, they want to go work somewhere for 2 months in Mexico versus a longer-term stint, like 6 months, a year, indefinitely.
Yeah. So, I mean, Elizabeth really kind of touched on that nicely just now especially in terms of the long-term commitments to that as it relates to hiring employees, internationally in other jurisdictions where different employment law applies, different taxation issues might arise, different occupational health and safety issues might arise. So, certainly there's going to be a significant difference there between, say, permitting somebody on a short-term basis to, work for a month or so from somewhere outside of their typical jurisdiction. I think you'd want to have kind of a pretty standard, remote work, like a temporary remote work agreement in place for something like that. You want to make sure that the employer has, authority and entitlement to ensure that person does in fact return to home base and continue on as agreed upon. The major risk factors are they're more so created the longer such a situation would go on. Things like all the things Elizabeth just mentioned, right? So if somebody's in another jurisdiction for a long period of time, which employment law applies? Is there any tax-related considerations? Are you complying with the local employment law? How are you managing things like software and document security? Just a real kind of host of issues that you'd want to set up something more permanent in that situation to ensure you avoid those risks. Okay, and then another one that I think is of interest, and so the question is, what are the risks with using monitoring software for remote workers? And so I'll send that one back your way, Leslie.
Sure. So, Jordan, you had touched on this a little bit when talking about the electronic monitoring. So, any employee monitoring raises privacy issues. Under privacy laws across Canada, generally, employees at least have to have notice of their information being collected. And in some provinces, they would actually need to provide consent or under certain instances. So essentially, employees, must know what the monitoring is, what it's going to collect, and what that data is going to be used for, and what the purposes of that collection is. It also has to be reasonable. It can't just be like, employer wants to collect all this information for, a broad range of purposes. It has to be reasonable and required for the management of the employment relationship. In British Columbia, our Office of the Information and Privacy Commissioner has mentioned that some electronic monitoring may be reasonable where, employees are working from home and the employer can't otherwise supervise them, but it has to resemble the kind of supervision that would occur in the office. So it can't be constant monitoring of every keystroke. It can't be covert surveillance where the employee doesn't know what's happening. And certainly we have seen cases with the OIPC here where there is that sort of constant, continuous monitoring, screenshots every 30 seconds, various tracking of all computer activity. That was found to be a breach of our personal information laws. But on the other hand, there have been some kinds of tracking that are okay, such as GPS tracking on delivery company vehicles that's only checked every so often. Here we go. And another question, as I'm going through the list that we originally had, for Jordan, what are the employer's responsibilities relating to occupational health and safety with remote workers?
Yeah, that's a great question. And from the general framework, the same principle applies, that the employer's responsible for taking all reasonable steps to provide a safe workplace to all employees. We know from the various workers' compensation bodies that a home office is an extension of the workplace for remote workers. So that same principle applies. Some of the specific stuff, certainly in BC, that we'd be looking for is, the employer ensuring that, the worker's aware of things like having like a safe location procedure, emergency evacuation procedure, requirements for, any ongoing workplace training, ergonomic considerations that we talked about should be, in check. And then the other thing is in BC, again, for example, we have certain additional rules for people that are, working alone or working in isolation. And so that's where you're going to see requirements that the person has like a check-in procedure and things like that to make sure that they're, they're safe when they're working at home on a day-to-day basis. But I guess I will say that could vary from province to province, and each province could have its own kind of unique health and safety obligations based on the location.
There's a great question in the chat just coming in from the audience live as well that sort of touches on this. So maybe I'll jump in with that one. So the question in the chat is would we advise putting into a policy that the employer can deny a work from home arrangement if the employee's home workspace isn't considered suitable or safe? And I think that's a great question. I think you can put those in because, it is still the employer's responsibility to keep the workers safe. And then sometimes there are workspaces that are not suitable for other reasons as well. So if you have a worker that, has no childcare and they've got all of their children at home with them, it might not be appropriate for them to be working from home if they can't make those arrangements. Now, the challenge there always, of course, is when you get into these sort of accommodation issues and the human rights aspect of things. But if we're assuming that those are not engaged by whatever's going on, then yes, absolutely, you can deny someone the right to work from home because their workspace is just not suitable for whatever reasons. And you have a fair bit of discretion as the employer in deciding what those reasons will be.
I was going to say, looking at another question in the chat, someone has asked a question essentially about constructive dismissal and calling employees back. So they wrote, we just informed employees that they will need to come back to work 3 days per week. Some employees say that their managers gave them permission to work from home since they moved away from the office. The managers are now all gone. What can we do? So as I said, this brings up a potential constructive dismissal complaint. If you, as the employer, say, actually, you must now come back, into the office 3 days a week, when previously there was an agreement potentially between the manager acting on behalf of the company. If the manager promised that the employee could move potentially, especially if they move a far distance away from the actual office, then you may have real issues bringing them back. If you can figure out whether or not that agreement, actually did occur, then there may be ways to try to bring the employee back. But obviously, if they have moved, quite a ways away, it may simply be that they are terminated, and then it would depend again based on looking at those facts, whether or not it would be termination without cause or frustration or cause because they're not responding to the employer's directive to return.
Okay, and just working our way down the list. Maybe I'll flip it your way, Elizabeth, if you like, since you talked about PEOs. The question is, who takes on severance liability when a PEO is the employer?
So generally the way the PEOs are set up, the severance liability is going to be the responsibility of the person who hired the PEO. And that will usually be dealt with very specifically in the agreement between you as the person hiring the PEO and your PEO. And usually what the PEO will say is, look, we'll make sure that the severance gets paid to the person. We'll help you understand what the severance obligations are, but we're not going to pay for it. You guys have to pay for it. And often, they will sort of skim off the top of that severance, or they'll take as part of their fee, those wages for the severance will count towards the PEO's fee as well. They'll sort of include that. So that's usually how those work. All of the kind of payments ultimately, flow back to the person who is really sort of directing the work. And the focus of the PEO is just kind of being the employer in name and making sure that they're kind of the employer for regulatory purposes. And then usually there will be an indemnity as well. So if the severance doesn't go well and there's a big dispute, then the employee, they're employed by the PEO, they may well sue the PEO and probably will. And then the PEO will be looking for some kind of an indemnity. And there's other ways that you can kind of build insurance and things to kind of deal with that. But that's usually how that works. I had one other interesting question that I liked out of the chat here. It says, would you recommend that employers include in their remote work policies a process for an employee to request an exemption, or would that be better in the employee's duty to accommodate kind of policies? I'm interested if Leslie and Jordan feel any differently, but from my perspective, I would definitely say don't put an ability to request an exemption, into the remote work policy because I think you'll just get too many requests for exemptions. I would put those in the duty to accommodate language. Like I would just basically default to that. And if employees are raising grounds that might be human rights grounds for reasons why they either do or do not want to work remotely, then I would default to your duty to accommodate policy. I think otherwise, you'll just get a lot of requests for exemptions.
Yeah, 100% agree with that. Have any other ones here?
I think we have time for maybe one more, and then we've probably got to wrap things up.
So one of the questions is, what if I need an employee to come in the office full time for performance and or attendance reasons? I think, certainly the starting point response to that question is yes, you can dictate where the employee performs their job from, particularly with a bona fide reason to do so. The answer to that question could be more complex if the employee's been working on a remote work arrangement without the understanding that they'll be required to come into the office in the future, or if they're being accommodated currently for a some type of issue or protected characteristic that permits them to work remotely. But notwithstanding that, certainly you're able to determine the location where the employee is performing their job.
All right, that's great. Thanks, Jordan, for being our cleanup hitter there. So that's our final question of the day. As we come to the end of our time together, I'd like to thank both you, audience, and my fellow speakers for being here today. On your screen, you're going to see 2 QR codes. One is for our survey. We really encourage you to fill that out because it helps us make content that is better for you guys, more helpful, more interesting. So we really appreciate your feedback. The other is for your Ontario or Quebec CPD certificates if you're hoping to get some of that today. We won't tell if you did a few emails and ate your lunch while you were listening to us. Links have also been added to the chat as well. For our BC viewers, the Law Society of BC title has been added to the chat, so you can add your CPD credits that way. We have one last slide for you because we wouldn't be good lawyers if we didn't have a bit of fine print. So our presentation today was intended to provide general comments on legal issues. If you have a specific issue that you need assistance with or asked a general question in the chat that you're actually thinking of something very, very specific that's happening in your workplace, please feel free to get in touch with us. We would encourage you not to rely on the very general principles that we're touching on today, because as we hope you've seen in the case law, everything does turn on its facts. So if you have specific questions, feel free to reach out to us. We're always happy to help. Our LEHR webinar series is going to resume in the fall. We're going to take a little summer break. We look forward to seeing you then. So thank you so much for coming and have a great afternoon.